Nobody expected Supreme Court Justice Amy Coney Barrett to directly call out Elon Musk during the high-profile hearing. The courtroom fell silent as she pointed directly at the tech billionaire, her voice sharp with authority. "Musk, your actions demonstrate a pattern of disregard for established legal precedent," she declared firmly. But what happened next left the entire judicial panel speechless. Elon Musk didn't flinch, didn't back down. Instead, he calmly opened a folder that would change everything. The legal challenge that was supposed to humble the world's richest man was about to backfire spectacularly. If you want to see true brilliance in action, watch this entire video and don't forget to like and subscribe for more shocking confrontations that the mainstream media won't show you. The stakes couldn't have been higher. The case Federal Communications Commission vs. Corp had reached the Supreme Court after months of escalating tension. At issue was whether Musk's social media platform had violated federal communications guidelines by refusing to implement certain content moderation protocols. Justice Barrett, appointed by former President Trump and known for her strict constitutional interpretation, had established herself as one of the most formidable legal minds in America. With her piercing intelligence and unwavering commitment to legal precision, she had become respected even by those who disagreed with her opinions. Elon Musk sat at the respondents' table wearing a simple dark suit and blue tie. No flashy billionaire attire. His lawyers flanked him, but unlike most defendants who let their legal team do the talking, Musk had insisted on addressing the court himself, a move many legal analysts called dangerously overconfident. The government's case seemed strong. For months, media outlets had been reporting on how Corp had flagrantly ignored established communication regulations. Legal experts appeared on news shows predicting Musk would face devastating penalties. The FCC had compiled what seemed like an airtight case with documentation showing patterns of non-compliance. This isn't just about regulations, the Solicitor General had argued in his opening. This is about whether private companies, regardless of their size or the wealth of their owners, must follow the same rules as everyone else. What nobody realized was that Elon Musk had been preparing for this confrontation for nearly a year, diving deep into constitutional law and precedent in a way that would soon shock the entire legal establishment. Justice Barrett began her questioning with surgical precision. The courtroom was packed with journalists, legal scholars, and spectators lucky enough to secure a seat for what had become the most watched Supreme Court case in decades. Mr. Musk, your platform has repeatedly ignored formal requests to comply with Section 230 modifications as outlined in the 2023 Communications Act. Barrett stated, her tone measured but stern. Would you explain why you believe your company is somehow exempt from requirements that every other communications platform must follow? Musk leaned slightly toward the microphone. With respect, Justice Barrett, that's not quite accurate. We've never claimed exemption from valid laws. Barrett raised an eyebrow. Your actions suggest otherwise. You've received 17 formal notices. 16. Musk corrected calmly. The justice's expression tightened. Excuse me? There were 16 notices, not 17, and we replied to each and every one with legal ration, as is established precedent. Barrett searched through her papers. The record shows the record furnished by the FCC is incomplete. Musk interrupted again. Something virtually never done to a Supreme Court justice. Audible gasps swept through the courtroom. Chief Justice Roberts looked like he was ready to intervene, but Barrett raised her hand slightly, saying she would address this. Her eyes narrowed. Mr. Musk, this court has little tolerance with technical corrections that fail to address the substance of the question. Your record of regulatory noncompliance is actually a record of constitutional compliance. Musk unfastened the folder in front of him to the end, and I think the court would be eager to see proof that the FCC has willfully misstated our position. The air was charged, Justice Sotomayor exchanged a look with Justice Kagan. Justice Alito leaned forward, visibly interested. Barrett's voice had an edge seldom heard from the bench. Mr. Musk, this court has read the briefs at great length. Are you suggesting the justices have somehow overlooked significant information? Not at all. Musk said I'm saying information was withheld on purpose from this court by the petitioners. The ER Solicitor General leapt to his feet. Your Honors, this is a serious charge without basis. Justice Barrett's voice cut across the chamber. Mr. Musk, those are extremely serious charges. Without material evidence, making such charges before this court could seriously taint your credibility in case Musk stayed unruffled. I appreciate the seriousness. Justice Barrett, which is why I've laid out evidence that the FCC's regulatory requirements themselves violate 3 separate Supreme Court precedents, including one where you wrote the majority opinion. Barrett's face didn't flicker, but those who knew her well could see the slightest whisper of surprise. Which opinion would that be, Net Choice versus Paxton 2024, where you made it quite clear that government agencies can't force private platforms to adopt content policies, effectively amounting to government speech controls by regulatory proxy? The courtroom was completely silent. This was not what anyone had been anticipating. Justice Thomas, who had sat quietly observing in the background, now spoke up. Mr. Musk, are you saying the FCC directives fall into that category? Yes, Justice Thomas, and I've done a detailed breakdown showing exactly how the FCC's lead counsel stood again. Your Honors, Mr. Musk isn't a lawyer. His interpretation of Justice Barrett's opinion is basically flawed and self-serving. Barrett, though, was already reading the documents Musk's team had handed over to the court clerk. Her face was unreadable, but she was clearly studying the material with intense intensity. Does the petitioner wish to challenge the authenticity of these communications? She asked, looking up at the FCC's counsel. The lawyer hesitated. We would need time to review what's been presented. Justice Barrett then did something unexpected. She turned back to Musk. You came prepared for this specific line of questioning. It wasn't a question, but Musk answered anyway. I did because the constitutional principles at stake extend far beyond my company. This is about whether government agencies can use regulatory authority to achieve what they cannot legally do directly. The atmosphere in the courtroom had completely transformed. What began as what many expected to be a public reprimand of a defiant billionaire had turned into something much more substantive. A serious constitutional challenge that no one had anticipated. Justice Barrett, known for her thoroughness, continued pressing. Even accepting your premise about the FCC's motives, your platform still ignored legally issued directives while you prepared this challenge. That's not how our system works. Mr. Musk's response was ready. Actually, Justice Barrett in Youngstown Sheet and Tube, Cumber v. Sawyer. This court established that when facing potentially unconstitutional government directives, parties may seek judicial review before compliance when irreparable harm would result. We filed for emergency stays in 3 separate circuits while preparing our response. Justice Barrett's eyes narrowed slightly, clearly reassessing the man standing before her. This wasn't a tech CEO playing at constitutional law. Musk had clearly done his homework extensively. Those stays were denied, she noted. By split decisions, yes. Musk acknowledged, but as Justice Jackson wrote in her dissent in the D.C. Circuit case, the constitutional questions were substantial and worthy of full Supreme Court review. Justice Jackson, hearing her own words quoted, raised her eyebrows slightly. The Solicitor General, seeing the shifting momentum, attempted to redirect your honors. Mr. Musk's legal theories don't change the fact that XC Corp has repeatedly violated clear regulatory requirements. Justice Barrett turned to him. Counselor, the constitutional validity of those requirements appears to be precisely what's at issue here. She turned back to Musk. Continue with your argument, Mr. Musk. What happened next would be replayed on news networks and social media for weeks. Elon Musk, standing before the highest court in the land, delivered a masterclass in constitutional law that left even his critics stunned. Justice Barrett, I'd like to direct the court's attention to page 47 of the materials provided. Musk said, his voice steady. These are internal FCC communications obtained through FOIA requests that explicitly discuss how to work around the constraints imposed by the net choice decision. Barrett reviewed the document, her expression growing increasingly serious. These appear to be authentic FCC memoranda. They are Musk confirmed. Note the highlighted section where Commissioner Thompson writes, and I quote, "While Barrett's opinion restricts our direct authority over content moderation, the technical compliance regulations give us an alternative pathway to achieve the same outcome." A murmur spread through the courtroom. Several justices were now reviewing the documents with visible interest. Justice Barrett looked up, her gaze intensifying. "Mr. Solicitor General, would you care to address these documents?" The government's lawyer appeared momentarily flustered. "Your Honor, without context, isolated communications can be misleading. The FCC's regulatory actions were taken in good faith to enforce legitimate public interest standards." The context is provided in the subsequent pages, Musk interjected, including meeting minutes where officials explicitly discussed using technical compliance. Regulations as a useful pretext. Their words, not mine, to pressure platforms into adopting specific moderation policies. This court had already deemed constitutionally problematic. Justice Barrett turned back to the Solicitor General counselor. "I would need to review these specific documents, Your Honor. They were not part of the record in the lower courts because the FCC successfully moved to seal them." Musk added, "We only obtained them 3 weeks ago through a separate FOIA lawsuit that concluded in the Ninth Circuit." Justice Alito spoke up. "Mr. Musk, are you suggesting there was a deliberate attempt to conceal these communications from the courts? The evidence speaks for itself." Justice Alito, the FCC knew these directives contradicted this court's ruling in net choice. Rather than respect that precedent, they sought to circumvent it through technical regulations. Justice Barrett was now fully engaged. Her initial skepticism transformed into deep judicial interest. "Mr. Musk, your legal argument goes beyond simply citing precedent. You're essentially claiming the FCC engaged in regulatory pretext to achieve unconstitutional ends." "Exactly," Justice Barrett, Musk replied. "And not just any unconstitutional ends specifically forbidden by your opinion less than a year ago." The moment was powerful. Barrett, who had begun by challenging Musk, was now visibly considering the substance of his argument with the seriousness it deserved. "Your Honor," Musk continued, "I'm not a lawyer by training, but I've spent thousands of hours studying constitutional law in preparation for this case, because I recognized something fundamental was at stake. When I read your opinion in Net Choice, I was struck by your clarity on government attempts to control speech through regulatory proxies." He then cited directly from Barrett's opinion. "When government power leverages regulatory authority to indirectly achieve what the First Amendment forbids it from doing, directly courts must be especially vigilant." Those words guided our response to the FCC's directives. The courtroom remained completely silent. Barrett was looking directly at Musk, reassessing everything about the case. Before her, the FCC's directives weren't about technical compliance. Musk continued. They were designed to pressure us into specific content moderation practices that would restrict certain viewpoints. The internal documents prove this was their intent from the beginning. Justice Barrett nodded slowly, then asked the question that would define the case, Mr. Musk. If your characterization is correct, why did no other platform challenge these directives on constitutional grounds? Musk's answer was simple but powerful. Because fighting the federal government requires resources and determination that most companies don't have. The easier path is always compliance, even with unconstitutional demands. I was fortunate enough to have both the resources and conviction to challenge overreach when I saw it. Barrett looked down at her notes, then back at Musk. Her tone had completely changed from the beginning of the exchange. Your legal reasoning is considerably more substantive than I initially anticipated. Mr. Musk, coming from Justice Barrett. Known for her exacting standards, this was extraordinary recognition. The Solicitor General made one final attempt to recover. Your Honors, regardless of Mr. Musk's legal theories, the fact remains that Exorb has refused to comply with legally issued directives while every other platform has managed to do so. Justice Barrett turned to him. Counselor, if these directives were issued as pretext for unconstitutional ends, as Mr. Musk suggests, and these documents indicate then widespread compliance isn't evidence of their legitimacy, but rather of the chilling effect such regulatory power can have on constitutional rights. The government's case was collapsing before everyone's eyes. What had begun as a seemingly straightforward regulatory enforcement action had transformed into a landmark constitutional case on government overreach. Barrett turned back to Musk. To be clear, Mr. Musk, your position is that Corp didn't refuse to comply with legitimate regulations, but rather refused to submit to unconstitutional government pressure disguised as regulation. Precisely, Justice Barrett, Musk confirmed. And we've documented every step of our constitutional objections, even as we were publicly portrayed as simply being defiant or non-compliant. Barrett nodded, then looked at her fellow justices. Something significant had shifted in the courtroom. What everyone expected to be a chastening of a tech billionaire had become a serious examination of government overreach. The Chief Justice spoke. I think we need to hear more about these documents. Mr. Solicitor General, the court will expect a thorough explanation of these communications. The triumph wasn't just that Musk had held his ground. It was that he had transformed the entire framework of the case through meticulous preparation and unexpected legal expertise. The Supreme Court took an unusual step 3 days later. Rather than waiting months for a decision, they issued an immediate administrative stay against all FCC enforcement actions related to the disputed directives. Legal analysts called it an extraordinary vindication for Musk's position. CNN legal analyst Jeffrey Toobin appeared stunned during a live broadcast. What we witnessed was remarkable. Justice Barrett, who everyone expected would be Musk's toughest critic, essentially validated his core legal argument. I've covered the court for decades, and I've never seen anything quite like it. The story exploded across all media platforms, hashtags like Musk Legal Genius and N. Barrett Musk. Showdown trended for days. Exusers shared clips of the exchange that had been captured by court sketch artists and later animated by news networks. Former Supreme Court clerks dissected Musk's arguments on legal podcasts, with many expressing surprise at their sophistication. He cited precedents. I had to look up, and I teach constitutional law, admitted Yale law professor Samuel Haverford on his popular podcast. Justice Barrett herself maintained judicial silence on the case, but sources close to the court reported she had ordered her clerks to conduct a comprehensive review of all FCC communications related to content moderation spanning back 3 years. The implications reached far beyond Musk and Corp. Other platforms began publicly questioning FCC directives they had previously accepted without challenge. Google announced it was reviewing compliance requirements in light of constitutional concerns raised in the Supreme Court. Facebook parent Meta filed a motion to join Musk's case as an interested party. Legal scholars began publishing analyses suggesting the case could become one of the most important First Amendment decisions in decades. Harvard Law Review fast-tracked a special issue dedicated to the constitutional questions raised. Meanwhile, the FCC faced mounting pressure. 3 commissioners were called to testify before Congress about the internal communications revealed in court. Documents released by X showed how extensively Musk had prepared, accumulating over 500 pages of legal precedent and analysis before the hearing. A week after the hearing, a former FCC staff attorney came forward as a whistleblower, confirming that there had indeed been an internal strategy to use technical regulations as leverage for content control. There were explicit discussions about using compliance as pressure points to force platforms to adopt moderation policies. "We couldn't legally mandate directly," she revealed in an interview. Justice Barrett found herself in an unexpected position. Widely praised across the political spectrum for her intellectual honesty in engaging with Musk's arguments, despite what appeared to be her initial skepticism. Legal commentators noted how she had demonstrated the exact judicial temperament she had advocated during her confirmation hearings. In tech circles, Musk's reputation transformed overnight. Beyond being seen as a brilliant engineer and businessman, he was now viewed as someone with serious legal acumen. Stanford Law School invited him to deliver a guest lecture on regulatory overreach and constitutional limits. The case wasn't fully resolved. Oral arguments would continue, and a final decision was months away, but the momentum had clearly shifted. Legal experts increasingly predicted a landmark ruling that would establish new boundaries on how government agencies could use regulatory authority when it intersected with First Amendment issues. During a press conference on the courthouse steps following the administrative stay announcement, a reporter asked Musk about his surprising legal knowledge. "I'm not a lawyer," he responded with a small smile. "But when fundamental principles are at stake, you make the time to learn what you need to know." Justice Barrett's previous writings on government overreach were actually my roadmap I just followed, where her own legal reasoning led. The reporter followed up. "Did you expect to change her mind?" "I didn't try to change anyone's mind," Musk replied. "I simply presented evidence and constitutional arguments I believed were sound." Justice Barrett is known for her intellectual integrity. "All I did was take her previous legal reasoning seriously and apply it consistently to our situation." As legal scholars continued analyzing the case, many noted the irony. The government had hoped to make an example of Musk by bringing the case to the Supreme Court, expecting Justice Barrett and others to deliver a harsh rebuke to what they characterized as tech arrogance. Instead, Musk had turned the tables using Barrett's own judicial philosophy to expose what appeared to be genuine governmental overreach. Perhaps the most telling reaction came from an anonymous comment reportedly made by a Supreme Court clerk. Everyone expected David versus Goliath with Musk as Goliath. What we got was a masterclass in constitutional law from someone who wasn't even supposed to be taken seriously as a legal thinker. The case continued to develop with legal experts predicting it would establish a crucial precedent for the digital age. All because one man decided to stand his ground and do his homework before facing one of the nation's most formidable legal minds. This wasn't just about Elon Musk anymore. It had become about the fundamental relationship between government power and free speech in the digital age. And it all started because a justice tried to intimidate a CEO who turned out to know her legal opinions better than almost anyone expected. If this video opened your eyes to how the system really works, don't forget to like, share, and subscribe. We bring you the real stories. The mainstream media won't cover the confrontations that change everything. Hit that notification bell so you never miss the truth about what's happening in America today.